The growing frustration among federal judges over the Supreme Court's opaque handling of cases involving the Trump administration has reached a boiling point. And this is the part most people miss. Many judges feel these quick, unexplained reversals are not just frustrating, but actually erode the foundation of our judicial system at a particularly fragile moment. In a rare and candid series of interviews with NBC News, 10 federal judges appointed by presidents across the political spectrum, Democrats, Republicans, and even Trump himself, express serious concerns about a troubling pattern. They explained how they invest enormous effort to meticulously study the law and render careful decisions in high-stakes cases involving the Trump administration. When their rulings do not favor Trump, those decisions are met with sharp criticism from the administration and its supporters. Following these criticisms, the government often rushes to the Supreme Court, which today holds a 6-3 conservative majority. Here's where it gets controversial. The Supreme Court increasingly steps in on an emergency basis to swiftly overturn these lower court rulings, dishing out brief orders with little to no explanation. A practice that was historically uncommon but has sharply escalated in recent years. 10 of the 12 judges fear this lack of transparency leaves their colleagues in the lower courts without clear direction on how to proceed, creating legal ambiguities. More troubling, these terse rulings seem to validate the administration's harsh accusations against the judiciary, wrongly painting judges as sloppy or biased. It is inexcusable, one judge said bluntly. They don't have our backs. All judges who spoke did so anonymously, often out of fear of retribution or safety concerns. Threats against federal judges have surged alarmingly, including bomb threats and swatting, a dangerous harassment tactic where fake emergencies provoke armed police responses. High-profile judges and their families have reported receiving violent threats, placing an unprecedented strain on judicial security. By mid-year, the U.S. Marshals Service reported over 400 investigations into threats against judges, a dramatic rise from 224 in 2021. The Marshals declined to provide newer numbers but acknowledged the growing problem, underscoring the precarious environment judges now face. Federal judges who deliver rulings unfavorable to the Trump administration have become targets, with some prominent MAGA figures and Trump himself publicly expressing hostility. For example, Trump went as far as calling for the impeachment of a judge who blocked a major immigration policy. White House Deputy Chief of Staff Stephen Miller has even characterized the judiciary as conducting a so-called judicial coup, a claim that the Supreme Court's current actions seem to tacitly endorse. One judge, who has faced physical threats and is now fearful of everyday sounds at home, warned that without serious intervention, a tragedy could occur. Somebody is going to die. With tensions escalating, 4 judges pleaded for Chief Justice John Roberts, as head of the judiciary, to take more assertive steps defending the courts against political attack. They argue the Supreme Court is essentially enabling the Trump administration's efforts to weaken the lower courts, effectively leaving district and appeals judges to fend for themselves. Another judge emphasized the necessity of the Supreme Court to provide understandable explanations for these emergency decisions. When the court repeatedly sides with the administration in shadowy emergency rulings without clarifying its rationale, it sends a dangerous message, one that empowers attacks on the judiciary's independence. This judge compared the court's pattern to endorsing Miller's narrative that the judicial branch is deliberately trying to undermine the presidency. It's almost like the Supreme Court is saying it is a judicial coup, they said. However, not everyone agrees entirely with this critical view. Some judges, including one appointed by President Obama, acknowledged the lack of detailed explanations from the Supreme Court, but cautioned that certain lower court judges may be reacting emotionally, influenced by what they call Trump derangement syndrome. According to this perspective, some judges might lose impartiality due to frustration with Trump's tactics. Let's unpack a key term, the shadow docket, coined in 2015 by a University of Chicago law professor. It describes a somewhat secretive Supreme Court process where cases are fast-tracked, bypassing the usual months-long consideration. These emergency cases often do not feature oral arguments and come with brief rulings, sometimes a few lines long. Historically, these types of orders mostly related to last-minute death penalty stays. But starting with the Trump administration, the shadow docket expanded significantly to cover politically sensitive national policies. For example, the 2017 travel ban against predominantly Muslim countries was fast-tracked using this process. The controversial increase in emergency applications reflects a broader trend. Presidents increasingly use executive orders instead of legislation, pushing the courts to respond swiftly. This rise in rapid, unexplained rulings has drawn legal scholars' critiques. They warn that the court's minimal scrutiny and rationale produce decisions of major consequence without the full procedural safeguards normally afforded. Since Trump resumed office in January, his administration has filed 23 emergency appeals to the Supreme Court to block lower court rulings. The court accepted 17, denied 2, resolved 3 without decisions, and has 1 pending. Notable rulings include temporary halts to lower court injunctions targeting Trump's plans to eliminate automatic birthright citizenship and efforts to fire federal workers. The court also sided with Trump in curtailing immigration policies, but pushed back in 2 key immigration-related cases. In comparison, the Biden administration submitted just 19 such emergency appeals during its entire 4-year term, with only 10 granted. An NBC News analysis revealed that 5 of the 17 Trump-related emergency wins lacked any substantive reasoning beyond terse statements. 7 others offered less than 3 pages of explanation. This trend of brevity extends to the Biden era, where even 8 out of 10 government victories lacked detailed rationale. Judges in the trenches need and deserve well-reasoned, bright-line guidance, one federal judge said. Too often today, sweeping rulings arrive with breathtaking speed but minimal explanation, stripped of the rigor that full briefing and argument provide. This lack of clarity makes it difficult for lower courts to interpret and apply Supreme Court decisions appropriately. A specific example highlights these tensions. In Maryland, U.S. District Judge Matthew Maddox grappled with the Trump administration's attempt to fire independent agency members at the Consumer Product Safety Commission. Such agencies are protected by precedent dating to 1935, Humphrey's Executor, which restricts presidential firing powers. Although the Supreme Court's conservative majority has eroded this doctrine elsewhere, it has not officially overturned it. In May, the court allowed Trump to remove members from 2 other independent agencies without cause. The order was brief and contradictory, simultaneously granting the request but postponing the ultimate legal determination. Left to interpret that mixed message, Maddox ruled against the administration, affirming that Humphrey's executor remained binding. However, the Supreme Court quickly reversed him in a short 1-page order, with liberal justices dissenting strongly, particularly Justice Elena Kagan. Kagan argued the majority was essentially dismantling a long-standing precedent without proper argument or ruling.